This is a prime example of why you should always have an attorney when you go to court. Is it mandatory, meaning under the law? Nope. Is it mandatory in terms of you not being end up screwed and knowing your rights? I would say yes. But anyway, he said he stupidly represented himself for a child support hearing and trusted that the government would not screw him completely. He received bonuses, a sign-on and a referral bonus, and as well as a pay from a second job he had temporarily in 2022, which both inflated his income and were disclosed in his financial affidavit. He thought that his child support would be around $450. However, after the final hearing, his ex somehow managed to up it to around $584 after claiming additional care costs for babysitting that she pays for her sister. First of all, your ex doesn't control the numbers. They can argue the same way you can make arguments, but ultimately the judge makes a decision if they're going to grant that or not. So when we say she managed to up it, she provided evidence to ask the court for more if the court agreed with her. Anyway, they also requested that he do back child support to the initial file. He now owes $12,000 retroactive child support. He's basically saying this is hitting him on his take-home pay. He has to pay for a train fare, all of these things. It just has a lot of expenses, and this is hitting him. Versus his ex makes less than $30,000. She has a bachelor's degree, and she's not working full-time. Well, at the time that she filed and you knew that, you should have asked to compel her to get full-time employment. You should have also asked for the court to impute full-time employment onto her because she does have an obligation. Did they give you the opportunity to make these arguments? And if they gave you the opportunity to make these arguments and you never made them, the court doesn't know. The court is only ruling on what's presented. So if you don't present the holes that's in her evidence and you don't argue the fact that, yes, I did make that money in 2022, but I'm currently not making that money now, and this is what my current income is now, they're only going to proceed with what's being asked and argued in front of them. And unfortunately, it sounds like that argument wasn't made. But if you don't argue those things, the court is sometimes not going to do it for you, depending on what judge you get. So it sounds like you didn't argue that, kind of lost the argument, and now are seeking to argue it again. If your income has changed from when that order was entered, even if you're saying, well, that was never my income, that wasn't my income with the order, well, just argue substantial change in circumstances, meaning I no longer make this amount of money, and this is now what I make. And it needs to be at least a 10% difference of what you would have made. But I would argue maybe substantial change in circumstance to those reasons. But if you're still within the 30 days, then just go for it on your own on the motion to reconsider.